Good afternoon, everyone. I'm happy to chat with you today, and I'm going to do a short presentation, just a verbal presentation, and I really would love to answer any questions you might have. I'm a avid supporter of reparations. As you know, I'm a not only a law professor and a activist, but as you heard, I'm a member of the National African American Reparations Commission and the African American Redress Network, along with my colleague Billy Wilkerson. We've worked on some of the most important campaigns around reparations that have taken place in the country over the last couple of years, including something I'm very proud of, the support of Robin Ruth Simmons' effort in Evanston, Illinois, who is, she's the reason we're here today. So I want to start off by thanking her for convening us and thanking Kiera for also convening us. I'm going to just speak for a few minutes about some of the legal concerns and questions that might be relevant for people looking to promote reparations campaigns around the country. And I actually would love to talk to you about any questions that you might have while I'm able to spend some time with you. And so I'm going to try to reserve a great deal of time for your questions. First of all, I would like to say once again that reparations are not only possible, not only are they politically feasible, but they are legal. They are legal. There is a legal way for us to obtain reparations. There is a legal path towards reparations. The United States Constitution, as interpreted by the Supreme Court, um, with all of its flaws, has the United States, 14th Amendment to the Constitution, has outlined a process wherein there can be a remedy for past harms under a framework that throughout our past couple of decades of political history has been articulated through the framework of affirmative action. Some of the most important cases in that jurisprudence, cases like Richmond v. Crossan, the case from the 1980s, which involved government contracting. Of course, many of you are familiar with Grutter and Gratz and Fisher, and most recently the Harvard and University of North Carolina cases on affirmative action in college admissions. Both of those contexts are the closest analogy that we have today towards a reparations plan or framework, either by providing some sort of admissions criteria that takes into account race, or that would be the Grutter, Gratz, Fisher, University of North Carolina, Harvard line of decisions, or on the grounds of something approximating government contract set-asides for minorities, which is the Richmond v. Crossan case. Of course, we have not had a case go before the United States Supreme Court deciding whether or not reparations is constitutional. So a lot of our discussion from a legal perspective in the United States context around the constitutionality of reparations is not going to be something we derive directly from a Supreme Court decision. It's going to be something that comes from activities happening in lower courts, or our closest analogy. Our analogies, like I said earlier, being affirmative action cases in the college admissions context, or cases in the government contracting context. But right now, both of those things are possible. There is a possibility of having set-asides in terms of government contracts, and there is a possibility of having affirmative action in the college admissions context. So our closest, from our analogy-based reasoning leads us to conclude there is a possibility for reparations, but there is a need to adhere to the strictures of what we call strict scrutiny when you create your reparations plan. What that means is, if your reparations plan involves the consideration of race, you're going to be held to something called the strictest standard of scrutiny, strict scrutiny in the analysis that is going to determine whether or not your plan is constitutional. So what that means is that your plan is going to have to be narrowly tailored to the precise harm that has been documented by your research, narrowly tailored to remedy the precise harm that is going to be documented by your research into the past atrocities that took place in your community. The city of Evanston provides an excellent example of a way to create a reparations plan that is narrowly tailored to address the past harms and ongoing effects of those harms created in a particular community. In the city of Evanston, there was a report drafted by the city itself, which outlined a history of housing segregation from 1919 to 1969. And as a result of that report and some other research that was done, we saw that there was a need for a remedy that would solve the particular problem outlined in the report, the housing discrimination problem, leading to housing segregation and generations of wealth inequities, as we saw the ongoing effects of that housing desegregation, the housing segregation. So as a result of that, the remedy, which was crafted by the city of Evanston, focused on housing vouchers, and even the provision of cash reparations, which I know the city of Evanston has only recently decided is appropriate. That second, more recent development also, in my belief, should be fully constitutional. The form of the reparation is not a deal breaker as long as the reparation itself is narrowly tailored to the specific harm that was outlined in the report documented by in this case, it was a city government. So one of the things that makes this plan so effective is the creation of very detailed reports by the city or by others who are able to verify the specific harms that took place that you're trying to remedy. So really, this really is an interesting element of our reparations discussion that I think is not talked about often enough. The first step in a reparations campaign is documentation of the harms that took place in that community. I am of the belief personally that the documentation should be as specific as possible, meaning that the best approach to documenting those harms is the approach taken by local communities, sometimes local governments, universities, churches, other groups that can put together very effective, precise reports that can then be verified, because the firmness and the constitutionality of your reparations plan will be determined by how verifiable and how accurate that report is. I think that in the long run, this is a positive thing for all of us. I myself, this is my editorial viewpoint. This is not a legal piece of this discussion, but my particular viewpoint is that the best way for us to move forward is to have all of our voices, local voices, at the table. It's important for us, as part of the 5 elements of reparations in terms of satisfaction and truth telling. It's important for us to be able to tell our stories, have our stories heard, have our stories responded to by the communities that created the harm in a very specific way. So we need to have those community conversations. So in a way, I'm glad that there is this constitutional mandate to ensure that we do have these very detailed stories uplifted and documented as part of our process of remedy and repair. So that has been a method that we've seen imitated and also extended even by the city of San Francisco, and of course the state of California, which is the first state to promote a reparations commission, as you know, with a report that was over 500 pages long. My own personal dream is that not only would cities around the country create reparations commissions and issue similar reports, but that states around the country would create commissions and issue similar reports of a similar length. And I do believe that if we can get every state that has a sizable population of people of African descent, Black people, to issue a report, maybe that's 20, 25, 30 states to do what California is doing, I think then we're going to be making real progress, because those will be local conversations that can then be promulgated on the city level, on the university level, on the community level, on the church level throughout those states. So I do think that the state of California has really begun something that can only lead us in the right direction. But once again, going back to some of these legal questions, though, I know that when you're thinking about legal justifications for a reparations claim, it's not only about this question of how your city's reparations proposal can be found to be constitutional under the 14th Amendment, which is the basis on which it would be challenged. But also some people may be interested in non city-based reparations efforts, whether they are lawsuits like we saw in the city of Tulsa around public nuisance claims, this idea that a particular atrocity was a public nuisance that perhaps could be remedied without worry about a statute of limitations problem. Maybe you're thinking about questions around unjust enrichment, if you're thinking about going after a private company that benefited, like an insurance company or business, bank, Wells Fargo, that benefited from slavery. Maybe you're thinking about other types of legal claims that could perhaps be brought on the state level. These are situations in which oftentimes you're going to be dealing with state and local laws, and it varies from state to state. In one state like Georgia, perhaps, there may not be a statute of limitations on a statute, for example, conversion. Conversion is a statute through which it is illegal to steal a person's property by changing the deeds or doing other things to change the laws. That's something that we know has taken place throughout the state of Georgia, where there were people, including people in my own family, my family is originally from Forsyth, Georgia, and there was a documentary called Banished, which described how people in my family's community were banished, were essentially ethnically cleansed from the city of Forsyth at the turn of the 20th century, and lawyers in that city stole the land of the people who were expelled. And in this situation, because there are laws around conversion in the state of Georgia, which do not have statutes of limitations, if a family member or a family wanted to bring a lawsuit to try to obtain a remedy, they would have grounds. We saw something similar happen in Bruce's Beach in California over the past year or two. In Bruce's Beach, you saw that was a political solution, but there was a lot of discussion around the legal pathway towards providing some sort of remedy, whether that legal pathway is against the government or against a private actor. There are legal pathways out there that go beyond reparations that is driven by a city government's passage of a law. So the legal pathway towards reparations is available. So the one thing that we need to do, and this is another prescription of mine, which is not based on research, but it's my own personal belief. We need to start to push the envelope. We need to start to bring more cases more aggressively. We need to have cities on a local level issue more widespread grounds for reparations. The Evanston model is a very sound model in which there's a very detailed type of approach for applying to receive reparations. But I'm excited about the possibility of a city saying that we're going to have reparations for all Black people, perhaps with very minimal application of an application process, with a more widespread amount of recipients on the grounds of race itself, and seeing whether or not that will be something we can argue about in court, because once again, the Supreme Court has not ruled on this case.